Good morning, everyone. Thank you so much for joining us. My name is Stephanie Hill. I'm the marketing manager here at Meyers-Milias-Brown, and we're so excited to host this presentation for you, COVID-19 Return to Work Plan, who returns, when, where, and how. A few housekeeping items for today. We are in webinar format. Therefore, that means you all are muted. So if you have a question, please feel free to pop those questions and utilizing the Q&A button at the top or bottom of your screen. And our presenters will get to those questions towards the latter end of the presentation. If we can't get to all of your questions, we will follow up via email. Feel free to utilize the chat feature for any technological issues that you may have. We will be circulating a copy of the PowerPoint, a copy of the recording, as well as any MCLE certificates that were requested through your registration portal. With that, one last note, I apologize. We are utilizing the closed caption feature. So if you find that to be a little bit of a distraction throughout the PowerPoint, please use the more button on your menu button and you can disable that on your end and therefore it'll hide. And without further ado, I will introduce our speakers, Camille and Arlene. Thank you so much.
Good morning, I'm Camille Hamilton-Pating, and I'm happy to introduce my law partner, Arlene Yang. Today we're going to be talking about your COVID-19 return to work plan. And we're happy to be able to interact with you this morning through this Zoom webinar. As Stephanie said, please feel free to drop questions in the Q&A and in the chat. We'll try to get to your questions even if we're not able to do so in this webinar. We'll make sure that we follow up with you. Next slide, please. As indicated, I'm Camille, this is Arlene. We practice in this area every day. We've tried to create this webinar around some of the hot topics that we're seeing from you, from our clients, and questions that we're getting about planning for return to work. Next slide, please. So this information in this presentation is subject to change. It is an informative presentation, not intended as legal advice. Please consult with an attorney for assistance with a particular issue or problem. You're going to be hearing us say this quite a bit during this presentation. Please consult with counsel. Return to work and all the areas that we're going to be discussing are all evolving areas of the law and new areas and untested areas of the law. We're all going through this together. It's very much like building the airplane while we're in flight. So the legal landscape and the regulatory landscape are changing constantly. The things we talk about today may be different very shortly in the future. So please keep this in mind as we proceed through this webinar. Next slide, please. So the agenda for today, as I indicated, we're going to be talking about some of the items that we find are the most frequently asked questions in this area or some of our hot topics. Returning to work, we're going to be talking about how to determine who returns, when, where, how, what about accommodation requirements, who has to be accommodated regarding return to work and who does not. Vaccination issues. We'll be talking about what your policy might be, whether mandatory, vaccine education, asking employees to provide proof, asking them if they have been vaccinated, and we'll also be talking about how employers should be acting on that information. Employees who refuse. What about employees who refuse to comply with your vaccination requirements or your health and safety policies? Workplace safety. So what are the new requirements and what about mandated legal reporting? Also, we're going to be talking about a particularly hot area, anticipating potential COVID-19 litigation and how employers can protect themselves from some of the anticipated risks. And finally, we're going to talk about considering diversity, equity, and inclusion in the return to work policies that you're going to be drafting and implementing. Next slide, please.
So just when we start thinking about return to work, we can go to the next slide. The big date that people have in mind is June 15th. That's the date, or June 16th, that's the date that the governor said we would want to have everything to be reopened the best that we can with everyday activities. That would be if the vaccine supply is sufficient and the rate of hospitalization remains low and stable. So what does that mean for employers? We're encouraging people to have plans in place. We wanted to find out from you what kind of plans you have. So if we could go to the next slide, we have a little poll. Does your company or organization have a return to work plan? So if you could just vote and let us know. As we're thinking about what's coming ahead, the last year has been a bit like whack-a-mole, right? So we have problems and then we're kind of reacting and always feeling a little bit behind. As we are thinking about what's coming up in the future, the number of new laws and rules are slowing down. So it's possible to kind of feel like you can get ahead of what the requirements are. And so we're encouraging you to think about plans so you can not have to have a crisis situation. And so if we can go to the next slide. So we have, so most of you here, 62% are saying that you're working on it. And 28% do have a plan in place already. So that's great. If we can go to the next slide.
So let's talk about what the plan should consist of. And, you know, to avoid stating the obvious, but we'll state the obvious, it needs to be a written return to work plan. Make a written return to work plan. Public and private employers are most likely going to be returning to work in stages, with some employees who are going to continue to work from home, either part-time or full-time, probably for an extended period of time. So this new workplace, which you often hear referred to as the hybrid workplace, we're anticipating the hybrid workplace, is likely to become the norm over the next few years at least. So instead of allowing this to happen in a haphazard way, you're going to want to create a written return to work plan. And that plan should detail who's going to be returning, when are they going to be returning, and the precautions that are in place to keep your employees and public safe. Many of these steps are going to take time. And if you have unions, you may have meet and confer issues. So it's wise to start planning now, start planning early. In particular, it's also helpful to have a written plan, because if you have challenges or litigation, you're going to want to refer back to that written document. Next slide, please. So let's talk about the first part, determining who returns to work. The focus really will be on getting employees who really need to be at the job site or in the office or on the work floor back as soon as it is safe and practical to do so. You likely will have three groups of employees. The essential services employees, who have most likely already been identified and most likely have already been working throughout the pandemic. Your mission critical employees, the employees who are important for the mission of your organization or your agency, and employees who can continue to work from home. So consider, in determining who is prioritized for return, which roles transition smoothly to working from home. Consider also surveying employees, especially the group who can continue to work from home, to determine who wants to return, who doesn't want to return, and who may have medical or childcare issues that they believe is preventing their return. Childcare issues can be significant for employees who have school-aged children, and employers may want to time reopening to coincide with schools reopening, which is anticipated for most school districts full-time in the fall, for those that are not already opening. Having this type of info really sets the table for a smoother process. And to the extent that you have to set up an interactive process for employees who may have disabilities or a mini interactive process for employees who are refusing to return or reluctant to return. This gives you at least a sense of the scope of the situation that you'll be facing, when you roll out your ultimate plan. Next slide, please. Let's talk about health and safety reopening procedures. So you're going to want to consider adjusting work environments. What does that mean? Adjusting reception areas, workstation areas, conference rooms and collaboration areas, your ancillary spaces and or your training rooms. And these spaces are going to have to be adjusted for appropriate distancing, for cleaning, prevention of virus spread, and for limited capacity in your office spaces. You're going to have to plan to provide PPE, including masks, gloves, sanitizer stations, cleaning supplies, and any other PPE that's going to be needed for the workplace. Also, providing for daily health checks. Both the CDC and Cal-OSHA recommend that all employers consider some type of check for employees coming in the workplace other than at home. And several counties have already issued health orders instructing all employers to create policies that require employees to complete health check forms before coming into the office. So these will have to be continued. Temperature checks and COVID-19 tests. Employers are allowed to conduct temperature checks and to require employees to take COVID-19 tests at the employer's expense. Employers will also need to plan for positive COVID-19 tests under AB 865, which will be discussed later in this program. Next. Okay, so MOUs. For employees or employers who have MOUs with their employers, you need to check your MOUs to determine if you may have collective bargaining issues and requirements of bargaining with unions. So for public agencies that are going to be implementing health and safety policies, you may have bargaining obligations which are going to be set forth under the Meyers-Milias-Brown Act or the MMBA. So the MMBA requires public agencies to provide notice and an opportunity for unions to bargain any decision that directly relates to a matter within the scope of bargaining. And the agencies have to do this before they make any of these decisions or implement any such policies. So under the MMBA, as an employer, you have to bargain until you reach agreement or reach impasse and then go through impasse proceedings. So currently, many of these issues that we're discussing relating to return to work have not been considered by the Public Employee Relations Board, has not issued a guidance or a decision regarding bargaining obligations. So given the absence of decisional precedent, you are going to want to consult with counsel. It may be the safest course of action for public employers who have MOUs to presume that these matters are going to be within the scope of bargaining and that employers must bargain before implementing a decision. There are certain exceptions, such as a necessity exemption and the emergency exemption. But as I said, they're not yet tested. We don't have any decisional precedent. So the safest course of action is to assume that you will be bargaining. Check also if you have zipper clauses in your MOUs or personnel rules that may relate directly to these policies that we're discussing. Zipper clauses are clauses in a labor contract that makes that contract the exclusive statement of the party's rights and obligations. So those may be relevant in your considerations. If you're planning to implement some of the policies that we're discussing, you may want to start speaking with your unions immediately and begin the bargaining process or begin the meet and confer process. Next slide. Things to remember. Your staff will need time to adapt to new ways of working post-pandemic. Make sure that the employees understand the expectations for them and the steps that are being taken to protect their health. Anticipate that there may be a potential uptick in personnel and compliance-related complaints as employees adjust to the return to work environment. And emphasize communication. That is really essential to reacclimate your on-site workforce, to identify potential problems as they're arising, and to strengthen your workplace culture and your employee engagement as part of this process. Next slide. So again, takeaways for employers. Key components of your written return to work plan. Assess your needs. Begin meet and confer as required for those with MOUs. Build trust regarding employee health and safety. Plan for accommodation, privacy, health and safety issues. We'll talk a little bit more about that. And lead with empathy. Leading with empathy is a tremendously important requirement that can't be overstated. Next.
Now we're going to take a look at some vaccination policy options. We can go to the next slide. We wanted to ask you, what type of COVID-19 vaccination policy does your company or organization have? Mandatory, voluntary, incentive plan? We don't have a policy. We don't know yet. We'd love to hear from you. As we know, we've had 28 million doses of the vaccine administered in California, with approximately 57% of the over 16 population who have received at least one dose. And we know that we need to have to develop some kind of herd immunity so that the virus is not circulating widely. We want to encourage as many people as possible to be vaccinated. So many employers are thinking about policies about how to encourage this and also how to protect their workforce or customers. Let's see our poll. We have a 37% say that there's a voluntary plan, 31% say we don't have a policy or we won't have a policy, and 27% say we won't know yet. Interesting, we have only 2 respondents who said that they have a mandatory policy. And then, so that's that's pretty much what we've been hearing as well. We can go to the next slide. So when you're thinking about vaccine policies, we want to think of 3 different main types that we've seen. One would be a mandatory policy, which is similar to this hypothetical here. There are also incentives that are provided, and then there can be a kind of a voluntary educational encouragement, but no formal incentives to get vaccinated. This hypothetical says everyone is eligible. After everyone's eligible and has the opportunity to get vaccinated, to come to the office or to attend events, you would need to be vaccinated. So let's think about, would that policy work? Some things that we want to think about, we go on to the next slide. We're going to look at some statutes that may impact this. There's first the Food, Drug, and Cosmetics Act. That is the statute that authorized the emergency use authorization for the Pfizer vaccine and the Moderna vaccine, and now Johnson & Johnson. Now, the statute has some language in it suggesting that the recipient who receives the vaccine must be informed of the option to refuse the vaccine. And some people have interpreted that as saying that that employers are not permitted to require recipients their employees to get the vaccine because there's emergency use authorization. We've already seen some litigation that's on this issue. The Los Angeles Unified School District had put out a requirement that their staff get vaccinated. And we've already seen a lawsuit in the Central District of California challenging that. And among the issues they raise is that they consider the vaccine to be experimental and that it cannot be required at this time. But so there's no guidance from the FDA. We don't have any litigation or court decisions interpreting what the actual meaning is going to be. We've seen so far the majority view seems to be that employers still can require it. But, just to know, this is, as with so many things related to COVID, it's a new area and it's not fully settled at this point. If we go to the next slide. Another thing that you would want to consider if you have any kind of mandatory programs is that they must have accommodations, reasonable accommodations for disability and religion. Both the EEOC and the California Department of Fair Employment and Housing have come out with guidance as to requiring accommodations for disability and religion. And what does that mean for employers? That's really just as an employer is responsible for engaging in an interactive process with any employee with disability for any other reason. You would also have to do it if you have a mandate for vaccines. And that of course would be involving an interactive process. There could be a request for medical documentation from the employee to show that this accommodation is required, and then there would be back and forth. This, of course, would be only if the employer has determined that there's a direct threat from having the unvaccinated individual in the workplace that can't be eliminated or reduced by reasonable accommodation. That's basically just to keep in mind. And then the similar issues would be related to religion. So there are some people have sincerely held prevent them from accepting vaccine, and then you'd have to engage in some sort of interactive process. And of course, this is something that is, whenever you have a reasonable accommodation interactive process, it's very variable. It's going to depend on the circumstances, what your organization is doing, what role that person has, what interaction they have with others. It's not going to be a one-size-fits-all situation. So you really need to, slow down, take a look at all the facts that are at play and determine whether accommodation is possible. So we can go to the next slide. Then the other option is incentives. We've seen many employers, especially private employers, they are providing incentives that may be available to encourage people to get vaccinated. That could be a couple hours of pay. It could be, we've seen gift cards, cash, childcare. There are different types of incentives that employers have offered for their employees. Now, what we want to be careful of when we have these incentive programs is that it's likely to be considered a wellness program, and the EEOC has had litigation and guidance related to whether wellness programs are voluntary or not. If the benefit is too great, it's not considered voluntary anymore, and the EEOC may challenge it. Is interesting because this issue has been unsettled for a number of years. The EEOC had issued some guidance in January on incentive programs, and then they withdrew it. So we're expecting that in the coming year, they will reissue guidance as to what they consider to be voluntary or not in terms of wellness programs. In addition, you want to think about, if you're giving these benefits to employees, you want to think about, is this taxable? You want to think about, for instance, if you're giving them additional pay related to it, is this going to affect the regular rate of pay and then overtime hours? There are just a lot of wage and hour issues you're going to want to think about too, and taxation issues. So you can't just offer them without kind of planning ahead. And
oh, excuse me, I'm sorry. I would add to that incentive programs are generally not utilized by public employers because of the financial incentive aspect of that is generally not appropriate in the public context.
So we've had some questions about if the vaccine is no longer emergency use authorization, will the option to mandate vaccine become more viable? And I think that certainly that argument regarding emergency use authorization will be less potent, but I think many people have already considered that is not a prohibition as it is right now. So some other issues that you want to think about is related to the EEOC issue, as well as whether requiring an employee to show proof of receipt of a COVID-19 vaccination is a disability-related inquiry. We want to be careful as employers to not ask employees to reveal disabilities unless there's some need that you need to know that information, right? So we're trying to avoid it as much as possible. And the EEOC has said, no, you are permitted to ask to show proof of receipt of a COVID-19 vaccination. When you have a situation where you're asking employees if they've been vaccinated, you don't, and they say no, you also don't want to be just come out and say, why haven't you done it? Because that could elicit a disability related information. So you could just make an option to say, well, if you need some sort of accommodation, please let me know, and this is the process how to do it, but not asking outright, what's your disability? Why can't you do it? So we have a question about how you can determine if someone has a sincerely held religious belief. So that's been a tricky area. We can provide you with guidance and kind of some steps on how to go through the process and make sure you are doing it. It's not going to be like you can get a medical note from a doctor. It's a little bit different process. And so then if we go into the next section, another option would be just to have a completely voluntary program and provide education. So the CDC and then their state resources, they have a lot of material that's available for employers that you can use to circulate to encourage vaccination among your employees. Go to the next slide. Again, we want to make sure if you're going to have any kind of vaccination policies, you're going to want to make sure that if you have collective bargaining agreements and unionized employees, that you are consulting with the unions to make sure that you're not going to be violating any agreements that you have. And there have been many reports that high numbers of police and firefighters are declining vaccination. And that's going to come if you have a lot of employees who are not willing to be vaccinated. That would certainly impact whether you'd want to have a mandatory policy. We can go to the next slide. So there are still a number of other considerations that you're going to want to make sure as you've considered when you're having a vaccine policy. There are the wage and hour implications. If you, for instance, if you require something to be done, such as having a mandatory vaccine, then the employer would be required to pay for the time it takes to get the vaccine, as well as any additional costs that may have been incurred. I'll get to this a little bit later, but for employers with 26 or more employees, there's a new supplemental paid sick leave related to COVID that does require that the time that it takes to get the vaccine or any recovery period would be required to have the special paid sick leave in addition to your regular paid sick leave. You want to have privacy considerations. The information as to whether someone is vaccinated is considered medical information. So this type of information should not be going into personnel files. It shouldn't be widely distributed. It should be only on a need-to-know basis. And you would protect it just like you would if someone has cancer or something. You're not going to be circulating that information. You're going to, of course, people are, in our workplace, people are saying all the time, I just got the vaccine yesterday. Of course, people are allowed to say that, but you can't make people wear stickers or buttons showing that they've been vaccinated. That would be considered medical information. And with these policies, you also want to think about whether you would have employee cooperation. If you have a situation where many of your employees are unlikely or unwilling to be vaccinated, it may not make sense to have a policy where you're requiring it or they'll be fired, because that would be very disruptive to your operations. You can also think, and then related to that would be the impact on recruiting, your business and your brand. as to what your policies are. And another thing just to remember is that even if your employees are vaccinated, we're still going to have masking and social distancing requirements. And I'll get into a little bit more detail about what the requirements are right now. But even as we see, yesterday the CDC said you don't have to wear a mask. If you're vaccinated, you don't have to wear a mask outdoors. And Governor Newsom said that California is going to follow. In the workplace and indoors, we don't see any changes related to this. So for many people, they'll still have to be wearing masks, even if they're vaccinated. So we can go to the next slide. And we're going to turn to Camille.
So let's talk about refusal situations, coming back to work or related to showing vaccine related documentation. Next slide. So when you contact employees to return, it's possible that they may not want to for various reasons. And it's important for employers to take a measured approach and a documented approach to make sure that the employees don't have a protected reason for refusing to return. You want to be reasonable in discussing the concerns that employees have and approach their concerns in the same manner that you would a good faith interactive process to make a determination on a case-by-case basis. And that's why we call that the mini interactive process. It appears that, in the future, as we roll out these return policies and make determinations on employees who may have reasons why they're declining or refusing to come forward, before making a determination to, exclude this person or take any action against this person, we want to make sure that you go through a case-by-case analysis. It is not legally required, but it is a good way to document that you as the employer have acted reasonably to determine that the employee does not have a reasonable grounds for refusing to return. Something that's important, I think, is that when you go through this interactive process with employees who are refusing, it may reveal other reasons that the employee has to take a protected leave, such as the voluntary FCRA leave for those who have extended and it is still in effect through September 30th, FMLA or CFRA leave, or it may show as you go through this process with each employee that they're entitled to other accommodations, as Arlene has discussed, under the FEHA or under the ADA. It's important that before you decide to exclude any employee from a work site who's refusing to be vaccinated, employers need to go through this type of process to determine if there's some kind of a direct threat by the presence of an unvaccinated employee. And that also is an individualized assessment. So those kinds of direct threat assessments focus on 4 questions: the duration of the risk, the nature and the severity of the potential harm, the likelihood that the harm will occur, and the imminence of the harm of having an unvaccinated employee on site. And so if you were to reach a conclusion that there's a direct threat, that would have to include a determination that an unvaccinated individual would expose others to virus on the work site. Next slide. Let's talk about vaccine information. So this is probably the #1 question that I'm seeing right now. And I think in part because so many places are talking about the vaccination passports or, venues that are opening up for people who are willing to provide proof of vaccination information. We're constantly being asked, can you ask for it? Employers who want to ensure a safe and a smooth reentry into the workplace may want to know if employees have been vaccinated. Can you require a proof of vaccination? At this time, the weight of information is yes, based upon the DFEH's guidance on this subject. Proof of vaccination is not a disability-related inquiry. It's not a religious creed-related inquiry. It's not a medical examination. However, because COVID-19 vaccination documentation can also contain other medical information, employers may want to make sure that when employees submit their documentation, that it does not have any other medical information on it. Any record of an employee or applicant vaccination, as we indicated, has to be maintained as a confidential medical record. As we also indicated, employers need to be careful about compliance requirements with the CCPA. So the CCPA, which is the California Consumer Protection Act, requires that certain employees get notice of categories of personal information that is collected for business purposes. So if employers start to collect medical information, such as vaccination results or testing COVID-19 testing results, those are going to have to be collected in compliance with the CCPA. What about asking for vaccine status? Yes, but employers may, according to the EEOC guidance under federal law, ask employees if they have received the shot. But keep in mind, as Arlene indicated, that entering into these types of conversations can be risky for employers, particularly if someone indicates that they have not been vaccinated. You have to be careful not to ask them why, because those kinds of situations very easily can lead to a protected medical inquiry under the ADA. Next slide. Okay, so let's do a hypothetical. An employee objects to your vaccination program and asks for an accommodation on the ground that they believe the COVID-19 vaccine is dangerous and ineffective. What do you think? Is that a good grounds for objecting? So generally, an employee's concern that the vaccine is not safe and that's the reason for needing an accommodation. Do you have to accommodate that? Probably not. Employers are only required to accommodate a disability or a sincerely held religious belief for not being vaccinated. So if you're confronted with this issue, make sure that you consult with counsel. But generally speaking, it must be a religious belief. Same as, concern about people who have concerns about wearing masks and things of that nature. It can't just be that I don't want to wear it. It can't just be that, I don't like it. I don't believe in that. But even so, again, we're in uncharted territory. So although most likely you do not have to accommodate this, you should check with counsel. Next. Takeaways for employers. So again, as you're looking at these risks and situations where people may refuse as you begin returning to work, consider the risks of discipline or termination of a large number of employees. We want to always be one step ahead of this and be anticipating it so that you can engage in these types of conversations with employees to determine whether or not they have a reasonable basis or a protected basis for any refusal to return to work. You also want to be careful about creating multiple individual exceptions. The concern about treating employees differently and carving out a lot of individual exceptions for employees can lead to litigation concerns. So this is part of, as we discussed early on, the importance of having a policy in which the expectations are set from the beginning, so that you're not being put in a position of having to potentially treat large numbers of employees differently with a lot of individual standards, which can lead to claims of unequal treatment. And again, for public agencies, consider and comply with due process concerns before taking any corrective action against employees based upon refusals. Next slide.
So we're going to turn now to looking at workplace safety. As I mentioned before, over the last year, we saw the new rules and regulations coming fast and furious, and it slowed down, but there's still some things that you're going to need to keep in mind. So if we could go to the next slide. The first is the Cal-OSHA Emergency Temporary COVID-19 Standards. That is currently in place starting in November of 2020 and currently through May 2021. We'll see there could be extensions of that, so we'll have to keep an eye out. The things that you really want to make sure, if you haven't done it already, is to ensure that you have a written prevention plan. And that is really quite detailed. The standard has many requirements that have to go into the plan, including how you're going to communicate the plan, identification and evaluation of hazards, how to investigate and respond to cases, how you're going to correct hazards, information about testing, and plan for notification when employees become infected with COVID. So all of those things are still in effect that we need to be paying attention to. I would advise you to review the standard in detail. We can assist you with that. And note that although, since we're in California, even if some of the restrictions seem to be lifting at the federal level, we still have to always comply with whatever is the most restrictive. And so we want to still look and see what California is requiring. There are some exclusions to having these plans. It might be if you have one employee where there's no contact with anyone, someone's working from home, or in situations where you have the employees who are subject to some other standard, like the aerosol transmissible diseases standard. So that's something you're going to want to keep in mind. And then especially as you're having more and more people in the workplace, in the office, you're going to need to have those processes in place. Then we can go to the next slide. Another thing that you're going to want to just keep in mind is workers' compensation presumptions. This standard has been changing during the COVID pandemic. In the beginning, from March to July of 2020, there was a disputable presumption that anyone who was working on site and was infected with COVID, developed it at work, and then it would be covered by workers' compensation unless the employer could prove otherwise. That presumption has ended, and then the current presumption is that it's a disputable presumption that first responders and healthcare workers developed COVID while on the job, or if there's an outbreak in the workplace, then it would be a disputable presumption that it was caused through work and then covered by workers' compensation. And then the statute defines what an outbreak is. 4 tests if you have less than 100 employees, 4 positive tests, or 4% of a location if you have more than 100 employees, or the workplace was ordered closed due to risk of infection. And also there's a mandatory reporting requirement so that it has to go to the workers' comp claims administrator within 3 days. So that's just another thing that you want to keep in mind as you have more and more employees in the office or on the work site. If we can go to the next slide. Then also we just have to be aware of COVID leave and reporting requirements. If we can go to the next slide. Those rules are also would be in your plan as well. I wanted to relate to the supplemental paid sick leave, which I mentioned earlier. This is a new statute, SB 95. It was passed this year, but it was retroactive to January 1st of this year. And it goes from January 1st to September 30th, 2021. It applies to public and private employers of 26 or more employees. And it provides for paid sick leave for COVID-related absences, in addition to paid time off benefits. So in addition to what's required by the state or your local area, you also may have to provide supplemental paid sick leave. And so some things that all employers who would be under this law need to think about is that in addition to, we're familiar from the Family First Coronavirus Response Act, which is no longer mandatory for most employees. We have the situation where there's some new requirements regarding sick leave, and that includes vaccinations. So it does require this supplemental paid sick leave if someone, the time that it takes for them to be vaccinated, and then also if they have, we've heard many stories about people having to take a day or two off after the second shot, especially because of side effects from the vaccine. That would also be required to be paid under the supplemental paid sick leave. This is a new requirement. And so it's really important if you are covered by this law to make sure that you've planned ahead. It could be retroactive. So someone who has, we're at April 28th. If it was between January 1st and April 28th that they had qualifying leave, they can request it, and then they have to be paid within a certain amount of time. And I do a lot of litigation. I see a lot of wage and hour cases, and many employers say, I'm counting on my payroll provider to make sure that everything that has to go on the wage statement is there. But you really can't expect that they're going to be able to do it. Many of these payroll providers are not focused on ensuring compliance with California law. And, we're in California, there are so many different requirements that are not required in other parts of the country. So one of the requirements from this new law is that if you're going to have supplemental paid sick leave, you have to put it onto the wage statement. So just, you're going to really have to plan in advance, making sure that you've got all these little details covered. So you're going to want to also provide training so that people know about, your managers and your employees know about this availability of leave. And also it's required under the statute that you post and distribute notice. So either posting it if people are in the workplace, or distribute it by email or something if people are not in an office or on the work site. So then, if we can go to the next slide. Another thing that you're going to want to be keeping in mind is notifying employees about potential COVID-19 exposure. This is AB 685, and this is a requirement that requires very, very quick turnaround in terms of if you find someone employee in the workplace has COVID, you're going to want to make sure that you're providing notice to potentially exposed employees. It has to be in writing, has to be within 1 day. It's going to go to the employees, subcontracted employees, and union representative. And it has to have information on COVID-related benefits, disaffection and safety plan. So this is just supposed to be within 1 day. Of course, you understand the reason why you want to do it quickly, because you want to make sure that people who may have been exposed can take precautions. However, at the same time, that means you need to plan ahead. So if you're going to plan to submit this in writing by email, make sure in advance you have everyone's email address so you can make sure you don't have to be scrambling within 24 hours to try to find everyone's contact information. And then you're going to want to make sure that you notify local public health agency within 48 hours. So again, you want to plan ahead, figure out who's the public agency you need to report it to and how you're going to need to do it, and have it in your plan so that when an exposure occurs, you can just put the policy in action. You don't have to spend time scrambling to figure out who to contact and things like that. So if we could go to the next slide. Then we want to think about reducing liability for potential claims. So a large part of my work, if we can go to the next slide, a large part of my work is defending employers in employment claims. And so I take a look every day at what new cases have been filed in all over Southern California in all the different courts, state and federal. And, you know, we're still seeing it's during the pandemic, we've still had many claims. Not a ton of them have a COVID twist to it, but the cases that we are seeing, you know, a lot of it is typical situation where someone has been terminated and then they're alleging wrongful termination, and then some sort of COVID related twist may be in part of it, like they may have complained about the workplace safety and then they're alleging that they were retaliated. And we see claims about paid sick leave, not following Family and Medical Leave Act, failure to accommodate disabilities. So we are seeing those claims. So it's just a matter of really trying to make sure that you're on top of what type of claims there were before to avoid litigation. And we are seeing increasing numbers of wage and hour and PAGA litigation, the Private Attorney General Act cases. So because I think part of the problem with these cases is that there are so many wage and hour rules, and then it's easy to make a mistake. Even when someone is well-intentioned, if it's very easy to make a mistake. Some issues that we've seen recently, especially relate to the time, making sure that people are compensated for every minute that they're working. For instance, if you were requiring employees to come in and have a temperature check and you're not paying them for that time, that is a risk for you. It could be, there are litigations regarding security checks related to bag checks and requiring that time be compensated. So you're going to want to think about if there are periods of time that are related to COVID compliance that are not being paid right now, and think about how you can address that. One thing that we do recommend, especially for private employers, is that if you have arbitration agreements for your employees. This is especially important because we've found it really helps to reduce the number of frivolous claims. Sometimes when plaintiffs' lawyers find out that there's an arbitration agreement, they recognize that it would be very difficult to get a very, litigation would be more difficult for them to get what they're looking for, and they may drop it completely. So we do recommend that. And next slide. Camille?
So let's talk a little bit about some of the impacts that you may want to be considering as you're putting together your return to work plan and all of the different elements that we've been discussing today. Next slide. We know from the CDC data that there has been a heightened and increased risk of COVID-19 infections in African-American populations, which the data ranges anywhere from 1.5 to 3.5 times higher than the risk for the Caucasian population. And so studies that look at hospitalization rates find a similar disparity in the percentage of COVID-19 death rates among African Americans in comparison to their percentage in the population. That's what's called the excess death rate. So African Americans show a 15% excess death rate. In other words, overrepresentation in COVID deaths in comparison to the percentage in the population. For Latinx population, the data from CDC is somewhat less conclusive because of geographic location variances, but it still shows disproportionality in terms of higher infection rates, higher hospitalization rates, And the excess death for Latinx populations, again, the death rate in comparison to representation in the population is plus 21%. And, you know, we know that there are some reasons that can account for that. Black, Indigenous, people of color employees tend to disproportionately be essential or frontline workers. So many of them have been working throughout the pandemic and have increased exposure. Many people from BIPOC communities also have increased pre-existing health risks. And also, as data regarding vaccination is coming in, Black and Latinx in particular populations tend to have or are tending to have lower vaccination rates. You know, and as we look at these factors, one of the measurements was about, you know, how close employees live to work. Are they able to walk? Are they able to bike? Are they able to get to work, you know, with less exposure? Do they have live long distances? Do they have to take public transit? These are all factors that you may wish to consider as you roll out these policies and how they're impacting your diverse workforce. Because as we have seen throughout the pandemic, disproportionate impacts on BIPOC communities, you may see similar disparities in the impacts of policies as they're rolled out. So we encourage you to, again, consult with counsel if you start to see these disparities, and consult with counsel on ways to mitigate these disparities so that they result in a fairer implementation process and also provide protection in terms of risk of litigation. Next. So here are our combined takeaways for employers. Update your policies, and your return to work policy, you know, will be part of this, but definitely an opportunity to update all of your policies that will be impacted by the new policies in all of these different areas that may be rolled out. Document, document, document. This is what we mean when we talk about all of the case-by-case inquiries that will undoubtedly need to happen as employees respond to the return to work or return to office or return to work site expectation, particularly those who refuse or who raise objections or concerns or disabilities or religious beliefs. All of your interactive processes, whether legally required or not, need to be carefully documented. Communicate your consideration and empathy. And again, empathy is very, very important. This is a stressful time for you as well as your employees. And so communication is going to be key in a successful return program. Consistent application of policies. We've talked about this, very important in terms of mitigating litigation risk and the balance between determining, you know, who has a protected reason for getting some accommodation and those who do not is very important in maintaining a consistent application. Consult your HR or legal department counsel early in the process. As Arlene mentioned, for those who have arbitration agreements, take those out, look at them immediately. Same as for those that have MOUs. And class action waivers also will be important in mitigating litigation for those who are able to utilize them. And that concludes our presentation for today. I think in terms of timing, we're actually right on the dot. But if we're not able to get to your questions, we see a lot of questions in the Q&A. We will make sure that you have your name there. We will make sure that we get back to you in responding to your questions. Thank you all for your attendance at the webinar today.
Thank you.
Yes, thank you. Thank you, Camille. Thank you, Arlene. Just as a reminder, we will, once we finalize the video, we will circulate a copy of the recording along with a copy of the PowerPoint, and we'll get to your questions as soon as we can. So thank you all for attending, and we hope you have a great rest of the day.